We're very lucky to have with us live in the studios once again, Jonathan Grant. Jonathan Grant is Executive Director of the Tenants Union of Washington. He has held that position since 2010. And he previously worked at Solid Ground, a community action organization. He has directly counseled over 3,000 tenants on strategies in asserting their rights across Washington and has successfully advocated for the expansion of tenant rights on the local, state, and federal level. Jonathan, thank you very much for coming back and spending time with us again this morning.
Thank you.
So start out, tell us a bit about the Tenants Union.
Well, the Tenants Union has been in existence for 36 years, and our mission is to empower tenants and transform unjust housing policies and practices through direct action, community organizing, and tenant leadership. So that can look like a lot of different things. The Tenants Union has 4 different primary programs. The one that most people are familiar with is our tenant education program, which is a hotline and walk-in clinics that are in Seattle. So this is a hotline that renters can call when they're having a problem with their landlord to learn information about their rights. If folks want to reach that hotline, it's 206-723-0500. And there are tenant counselors and volunteers on the line that are trained in landlord-tenant law that can kind of give you strategies and the laws that can help you resolve your housing situation. It prevents homelessness and increases public health and all these good things.
Is that a 24/7 line or is that business hours?
It is not 24/7. Unfortunately, resources are limited, but we are constantly building resources to make sure that the hotline is as accessible as possible. The best thing to do is for folks to go into the walk-in clinics, actually, because people from all across the state are calling the hotline. For information on those locations, they can go to our website at tenantsunion.org. So that's the tenant hotline. We serve over 2,000 people a year, but there are many more people that try to call the hotline. So our other main program is the Section 8 Tenant Organizing Project. And sorry, I just pushed a button on this desk. Is
it's
that okay?
I got it back on.
Okay. The other one of the other main programs of the Tenants Union is the Section 8 Tenant Organizing Project, or what we call STOP. STOP is a statewide program. We actually have an office in Spokane, where we have our Eastern Washington community organizer, and then we have our Western Washington community organizer. And what these folks do is that they go into HUD-subsidized buildings, or what are called Section 8 project-based buildings, and organize tenants who are facing displacement because that subsidy that keeps their rents low could expire, or the landlord could opt out of it. And so tenants organize into tenant associations so they can collectively bargain with the owner to keep the building in the program and keep rents affordable. In the lifetime of the program, the Tenants Union has preserved 8 different properties, which are home to over 400 low-income families. One of the kind of offshoots of that, which is another program, is our tenant ownership program. And this is where tenants that are in subsidized buildings, like a federally subsidized building, if the owner is trying to opt out and displace those tenants, we've been able to organize tenants to actually purchase the property and own the property so that the tenants can maintain affordability in perpetuity, because obviously they would never opt out of the program. So we were successful in doing that in Washington State's first tenant-owned property in Kent, Washington, at the Benson East duplexes, which is about 35 different buildings next to in one community. And it's an amazing community. It's very diverse. People have these amazing gardens that now flourish there, and it's there's about 5 or 6 different languages spoken in that community. So you have these community meetings that have interpreters there, and it's like this cacophony of different languages, like Vietnamese, Romanian, Russian, and tenants work together in their tenant association to kind of maintain and make sure that the property continues on in perpetuity as an affordable housing. So then there's our healthy homes organizing work. So the healthy housing organizing has to do with when a landlord fails to make a repair, and a pipe breaks, or your roof caves in, or you've got a rat infestation, or what have you. Usually we find out about people in that situation who come through our hotline, And we have community organizers that can go and meet with tenants and actually have like a tenant meeting to discuss what are collective ways that those renters can actually put pressure on the landlord to fix those situations. So we're currently in the beginning stages of a campaign to organize with tenants in South King County, where there are some of the worst substandard conditions in King County. So the Healthy Housing Campaign had a very huge victory in the city of Seattle, where tenants who are living in substandard housing organized with the tenants union to fight for a campaign to establish a proactive rental registration and inspection ordinance, which is a sea change for tenants' rights in the city of Seattle. And what was important about that victory is that if you were a tenant living in substandard housing and you had a problem and the landlord refused to fix it, the onus was on you to enforce the city's codes, the building codes, right? So you'd have to go and file the complaint with the city and make yourself a target. Well, we thought that was backwards, right? We wanted rental housing to be established more as a business, right? And like if you go to a restaurant and you have an expectation that there's a regular health code inspection to make sure that this place is a safe place to eat, right? Well, that standard does not exist in rental housing. So what this did is that it created a proactive program where properties will have to register and establish through an inspection that they meet the most basic health and safety standards. So, for example, does the plumbing not leak? Is there a door? Things like this that are calls that we get, hundreds of calls that we get every year on the hotline. So that was a big change in Seattle, and this is the first year that the program is just in its beginning phases, and the city's just getting it up and running. But that was a huge win for tenants' rights to make sure that people can live in healthy and safe homes.
Assuming that continues on in Seattle, do you see expanding that to other cities in King County
yes,
or to the county?
Yeah, and not necessarily specifically a proactive inspection program, but one of the biggest impediments to tenants being able to assert their rights is retaliation. And Seattle has another law in the books that the TU got passed a number of years ago called the Just Cause Ordinance, where in the rest of the state, if you have a problem with your landlord or they don't like the way that you look, they just give you a written notice with 20 days to get out, essentially. And there's no justification for it. So in Seattle, the Just Cause Ordinance states there needs to be a reason. You need to state a specific reason why you're terminating the tenancy. And it has to be one of 18 different reasons. And if it's not on that list, you can't just kick someone out. That doesn't exist in the rest of the state, so tenants are extremely vulnerable to retaliation. And we get a lot of calls in the city of Spokane, where there are a lot of renters who are facing substandard conditions, and then when they try to get that situation addressed, either to get rid of the mold in their house or make sure that the plumbing is working, that there's heat, that the common response from many landlords who are unscrupulous is that they'll just give them a 20-day notice and be like, you don't like it here, too bad. And we think that that's really problematic because there is a fundamental power imbalance between landlords and tenants, right? So Just Cause is a really important policy to make sure that displacement like that doesn't happen, and to ensure that city codes are enforced so people feel better protected to actually go and file that complaint when there is a landlord who's not following the law.
How many landlords are just people who own like a single property or a couple properties versus the landlords that own, multiple large facilities? Do you have a sense for that?
Yeah, well, in the city of Seattle, there are many, many people who live in single-family homes or mother-in-law units. It's almost, I'm not sure the number, but I think it's almost half of the rental housing stock. So when you take that into consideration, there's an even smaller subset of housing that is publicly subsidized. So that's like Section 8 or public housing or something of that nature. And because there's such a limited pool of affordable housing that's subsidized in that way, people are left to kind of be subject to the whims of the market, right? And that can be a real problem in a hot market like Seattle, where it has these jumps and these dips in terms of costs. And whenever the market jumps in that way, it displaces many people. And lots of other municipalities actually have the ability to regulate when those rents jump like that, and make sure that rents are tied to something like the consumer price index. And so there are many cities all across the country where they've been able to regulate rent increases in this way. Seattle can't, unfortunately, because of a state ban passed in the 80s that basically prohibits local control over how to regulate the rental market, and it's really prohibitive in the city of Seattle.
And was that enacted from efforts by the landlord lobby?
Yeah, I think that's a pretty safe assumption. The landlords obviously don't like the idea of their profits being limited in any kind of way, and this has a huge impact on communities, particularly low-income communities and communities of color, because whenever a building is identified by a developer, it's going to be in a low-income neighborhood because that's where it's cheapest to purchase a property. And so what we're seeing in Seattle right now, when there is such a limited supply of housing and a very limited amount of land to build that housing, it's the housing market just kind of devours itself. And these rental properties that were at one point affordable but not subsidized get bought out and renovated and turned into high-cost units or converted into condos, right? So this is a real problem. There is this myth about the housing market that supply and demand will solve this problem. Let's just build more units, more supply, more supply, more supply. That'll lower prices. Well, we've been living in an unregulated rental market since forever, and I think anybody who's listening can say the rents aren't getting any cheaper. Actually, interestingly, last year, just in that year alone, there were more units built than in the last 2 decades. But Seattle was number 1 in the nation for the highest rent increases. So you can't tell me that supply and demand is the answer here, because you have to consider the context that the market exists. Supply and demand works great for things like commodities, like telephones and things like that, right? Because you can make as many or as few of them as the market may need. When you apply a market-based economy to something like land, there is a limited supply of land, right? Seattle is bordered by 2 large bodies of water. It's kind of like an hourglass. And in the middle of that hourglass, where there are still affordable apartments, those are the first ones to go. They get bought up by these really large developers, these multi-billion-dollar entities, and there's no real benefit. For example, right now, there's a huge problem at the Lock Haven Apartments, which is up in Ballard, and they've been in the news a lot. The tenants self-organized. They actually formed an association when their building was in the process of getting bought out by Goodman Real Estate, and the tenants union has now been working with them, providing technical assistance to them to try to negotiate with the developer to make sure that not everyone is being displaced. And what we see when these situations happen is that the developer, this building had decades of life left in it. It didn't need major capital work on it or anything like that. But what happens is that the owners will sell it to a large developer. The developer purchases it by getting a massive loan from a bank, and then to in order to accommodate that financing, they double or triple the rents just to service the debt on the loan they used to purchase the building, right? So who does this really help? It helps large banks and large developers. It does nothing for our community. In fact, it decimates our community when we lose buildings like this. Because these are the buildings where there are low-income workers, where there are seniors, where there are people with disabilities, and there are these last few remaining pockets of affordability that, again, because of the limited nature of land, developers will go in and just, we call this a predatory acquisition, right? They'll just seize this property, get a massive loan, triple, double the rents, and then everyone gets displaced out of the city. Now, if we want to be, a community where we value inclusiveness, where we value diversity, an unregulated rental market doesn't speak to those values. And that's not the kind of city that I want to live in. And I don't think that's the kind of city that Seattle considers itself to be. I think that we need to be thinking outside of the box and creatively about how we can address some of these things and not worry so much about what the state limits our options to. And we need to start building community pressure and political pressure to change the status quo. Because in 10 years from now, the city of Seattle is going to be a minority of very low-income tenants in publicly subsidized housing, and then extremely wealthy people, and there'll be nowhere in the middle for people to live. And that's what's going on right now. Building by building, they're being bought out, taken down, made more affordable, or not made unaffordable, and it's displacing people en masse in the city. It's a housing crisis, and we need to wake up to it.
Do developers often end up then becoming the landlord for the buildings they build, or do they pass that on to a parallel?
It totally depends. Often they'll hire like a property management company to manage the property, and they're kind of just sitting on the asset and collecting the revenue from it. That's typically how it works.
All right. Well, there are several pieces of legislation that are proposed in Olympia right now, and I'm hoping you will illuminate us on those, starting with Senate Bill 6192, the Fair Tenants Screening Act. Can you talk about that?
Yeah, so Senate Bill 6291 is the Fair Tenant Screening Act. And, before I jump into it, I just want to make a request for all the early morning Seattle tenants to go to our website at www.tenantsunion.org. And right on the landing page is a link that you can click to learn more about some of these really important tenant bills and how to contact your legislator and let them know that they need to both protect tenants' rights and stop the landlord industry from repealing the rights that you already have. So really, I implore you, go to the website. This is a really important legislative session for tenants. To give you a sense of what's been going on, last year, when the Majority Coalition Caucus took control of the Senate, it was a conservative majority that was really pushing hard on advancing the interest of the rental industry. And they introduced 12 anti-tenant bills that ranged from, making it harder to protect people from carbon monoxide poisoning, to making it easier for the landlord to toss out your stuff if you're deceased and the estate wants to try to get your possessions back, all sorts of terrible stuff. Well, thanks to the broader tenant community and the tenants union membership, we pushed back on all 12 of those bills and were able to stop all of them from getting passed. And it's when tenants contact their legislators and use the tools available to them on our website at tenantsunion.org that it really we're able to push back on these anti-tenant bills. So the Fair Tenant Screening Act is a bill that the Tenants Union has been working with the Washington Low-Income Housing Alliance, which we're a member of, which is a broader coalition of housing justice groups. And we've been working on this bill for many years. When we first introduced it, I think 4 years ago, it was a comprehensive kind of retooling of how the tenant screening process works. And for those that aren't familiar, when you go to apply for housing, often you pay that $35 to $50 for a background check. Now, the landlord doesn't actually do that. That money gets forwarded to a tenant screening company, and this third-party company gobbles up all this publicly available data from the court database, from getting criminal records to getting your credit report and all this stuff. So they compile it into a report, send it back to the landlord, and the landlord decides to rent to you or not based on what they see. Well, that information is all coming from the same public sources, right? So the reports from the different companies that produce it are more or less the same. So what happens is that you go to apply for housing in one place, you pay the $35 or $50, you get denied, let's say. You go to another place, you pay another $35, you get denied. Another $35, you get denied. It's this repetitive screening fees that are outrageous and totally unfair in terms of the tenant, because the tenant is the one paying for this product, right? And then they never get to see it once they get denied. They have a right to ask for it, but they don't automatically get a copy of it. And then if you wanted to use that report again, the landlord at the next place you go to doesn't have to accept it. So what this would do is that it would be a common sense solution that if a tenant pays for this product, for this tenant screening report, that they can ask this company that produced it to forward it to the next prospective landlord that they want to apply to. So they pay once, and then they can forward it to like as many places as they want to for a 30-day period. It's a really simple solution. We think that it's fair to the industry, and it doesn't create this massive licensing scheme or anything like that. And we're still getting pushback from the industry, and they're crying bloody murder about it. We would like to put this issue to rest, and I think that it's time that the state legislature act and make this really important change, because when we talk to people, they're paying hundreds of dollars in screening fees. I spoke to a family that paid over $600 in screening fees. That's a first month's rent or part of a deposit for the place that would eventually accept you. And with the rent increases that are going on right now, people just can't afford to just waste their money in this way. So we think that it's a really common sense solution, and we really like to see it get passed. We've had some success. Rather than pushing the comprehensive bill like in the first year, we've been breaking the bill up into smaller pieces. And so thanks to advocacy by tenants and also by our broader coalition of housing advocates, we were able to get a really important piece of the Fair Tenant Screening Act passed last year. And this was a part of it that would protect domestic violence survivors. And I think that's what's really shocking but maybe not surprising, is how much opposition even the most sympathetic parts of this bill gets from the rental industry. What that part of the bill did last year was that if you were a survivor of domestic violence and got a protection order against your abuser, that becomes a public record that anyone can see. What screening companies do, because they mine those public databases, is they include it in the report. And that report goes to the landlord, and they see that you got what's called a DVPO, or Domestic Violence Protection Order. So they see that, and they say, oh, wow, I don't want to rent to that person. That person's trouble. Well, actually, it's illegal to discriminate against DV survivors. You cannot do that. But it's not illegal to include it in the report. So this was actually a result of, that it wasn't always like that. It used to be legal to do this. So in 2004, they passed legislation saying, no, you cannot discriminate against DV survivors. And part of that bill was prohibiting screening companies from including that information in the report. But that part of the bill didn't pass, right? And the reason that it didn't pass was because the industry knew that they could say that it was illegal, but then still clandestinely discriminate against DV survivors, because they'll be able to see it on the report, and then they can say for any reason or no reason that they're not going to rent to this person. So it was a really big victory for, not just tenants, but women, in particular DV survivors, that we finally prohibited that information from being included in screening reports. So that was a really big win, and I want to thank everybody who called their legislators to put pressure on on Olympia to make sure that happened. Because you wouldn't believe it. I mean, I encourage people to watch the industry's testimony against that bill. It was appalling. You have landlord trade associations going on their record saying, it was great. Senators would ask them, well, it's already illegal for you to use domestic violence records in your rental decision. So why do you need that information in the report? And they'd sit there and say things like, it's a First Amendment issue. We should be able to see whatever we want. And I'm sitting there with my mouth open. I'm like, are you kidding me? Like this, first of all, that's like the most mind-boggling answer to begin with. But then you'd even have other people going on their record being like, well, sometimes it's really important to know that kind of stuff. And our thing is, well, aren't you opening yourself up to a liability by even having it in the report if it's illegal? Couldn't you get sued? Which the answer is yes. Couldn't you get sued for discriminating against somebody in that way? And still, you're arguing against it. So that was a really important win for getting that part of the Fair Tenant Screening Act passed. This year, the focus is on affordability. How can we make it more affordable? And we think that by having the report be portable, to be reusable for that 30-day period, is a really great compromise.
All right. Just 4 minutes left. SB 6292.
So Senate Bill 6292 is an attempt to address the massive rent hikes that are going on across the city of Seattle and in other parts of the state. As I was saying before, there's no local control to regulate rents. And so landlords and developers are making these insane profits. And because we're preempted at the state level, we're trying to figure out what are some other ways that we can at least mitigate the impact that's happening to tenants with these rent increases. And so this bill would go a long way towards allowing people to save up money to move if they are actually being displaced. So what this bill does is that it changes the state law from a 30-day notice to a 90-day notice, so that if you get a rent increase, the landlord has to give you 90 days before it goes into effect. So it's going to be a really hard push for this because it's currently being heard in the Senate, which again is very conservative. And this is a very modest ask, to give people more time to save money to move. I mean, and they're already screaming bloody murder. They're saying this is, you're trying to, do rent control, or you're trying to do all these things. And that's not what this bill is. It's just a reasonable amount of time that people need in today's rental market, where you have to pay first month's rent, last month's rent, and a deposit to move somewhere else. The other thing that it does is that it increases the eligibility limit for relocation assistance, so that if you do get displaced, the city can provide the landlord and the city can provide relocation assistance for tenants who make a moderate income. Now, the area median income in Seattle is about $60,000 a year. So we're asking that people at 80% AMI be able to be covered by this because of the particularly high costs in the city. I think it should be noted too that in the city of Seattle, if you were earning a minimum wage, that you'd have to work 92 hours per week in order to afford a standard 2-bedroom apartment in this town. 92 hours a week. So this is a very modest request.
All right. 2 minutes. SB 6143, the rat bill.
Okay, again, so this is the 6143 is what we call the rat bill. So this is a naked attempt to strip tenants of their most fundamental right to live in healthy and safe housing. Now, under current law, when you move into a rental unit, there is not just an assumption, but by law, it's implied that the landlord has to actually make sure that it's healthy and safe. Now, that was established by case law, decades ago, and this is called the implied warranty of habitability. It's kind of like when you buy a car. If the engine seizes up, if you have a warranty, the manufacturer has to replace the engine, right? Well, there's an implied warranty when you move into a rental home, that it be habitable. That's what the implied warranty of habitability is. This would actually strip that right away from tenants. And what it would do instead is that it would just default to the state statute, and the state, the legislature created the Residential Landlord-Tenant Act to kind of regulate relationships between landlords and tenants. So, for example, there was a case that came out that kind of inspired this bill. And the case basically said, only the statutory law applies, not the case law. Well, that was the argument that was being made by the landlord industry. Well, the justices disagreed, and they said, no, the implied warrantability is a fundamental right. It exists separate from the state statute, period. This law would repeal that court decision. And in that case, it was a situation where the tenant leased an apartment, was in the process of moving in, and there was dead rats in the walls and a rat infestation in the unit. And this is a public health issue. So the tenant moved out, and the landlord didn't give him back their rent money for that situation. So the justices said no, like it's not that tenant's fault for living into a unit that you let be infested with rats, right? So this would overturn that decision. And so we think that the legislature should strongly oppose this. It's a very good chance that it might get through the Senate. And so the House of Representatives really is going to have to try to stop this bill. If you go to our website, again, please send an email. This is a terrible repeal of tenants' rights. And in particular, it should be noted that it's being sponsored by Senator Mike Patton, Republican from the 4th District, and also Senator Tim Sheldon, who's a Democrat, who is one of the Democrats that turned and joined to form the Majority Coalition Caucus. So it's kind of, it's a very anti-tenant bill, and people need to vote no against rats and slumlords.
We're talking with Jonathan Grant. He's Executive Director of the Tenants Union of Washington. And again, your website and phone number.
So our website is www.tenantsunion.org. And our phone number for our tenants' rights hotline is 206-723-0500.
All right. Well, with that, we're unfortunately out of time. I want to thank you very much for coming and spending time with us.
Thank you.